All right, good morning, everyone. I'd like to reconvene the Judiciary Committee public hearing for Monday, March 11, 2024. We have 8 bills on our agenda today. I apologize for the delayed start this morning as the committee took up other business this morning. But let's jump into it. We have about 20 people signed up to testify today. So we will start with Megan Scanlon.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and the members of the committee. CCADV is here today to urge the committee to support the following 4 measures. I'll start with first Senate Bill 359. We support the proponents of this measure and their efforts to ensure information regarding options of guardianship or custody be provided to next of kin when there's a victim of intimate partner homicide that has surviving minor children. So the purpose of this bill is to assign an IPV, intimate partner violence specialist, from the Department of Children and Families to relatives of the deceased parent, so that they're able to be provided with necessary resources. That IPV specialist will then identify all of the grandparents and other adult caregivers of the child, subject obviously to any domestic violence, who could potentially care for the child. The second measure, House Bill 5326, we support this bill because we believe it provides clarity for both the court and protected party on the extension of a family violence restraining order. Specifically, lines 13 to 17 of this bill mirror language that's found in the state of Massachusetts relative to the extensions in the absence of continued abuse. And then third, House Bill 5414, we support that bill. Our sister coalition, the Alliance to End Sexual Violence, is looking to expand their anti-discrimination laws to include individuals based on their status as victim of sexual assault. In 2022, the General Assembly did pass these protections for victims of domestic violence, and we believe that they should also do so for victims of sexual assault. And then lastly, House Bill 5418, we support the proponents of this measure and their efforts to expand the eligibility for family violence education programming, given the concerns that law enforcement may not make the arrest for risk of injury the felony charge, because doing so may preclude a participant from participating in a family violence education program. We do want to clarify, though, that charging risk of injury when there is probable cause is critically important for the safety and well-being of the child and the other parent. However, we do understand that offenders learn this behavior over time, and they certainly do not grow up seeking to be an offender or become abusive. So we do believe that with the appropriate efforts, the individual can change and unlearn that behavior. Lastly, I would just mention on this bill, the General Assembly did pass into law last session the Domestic Violence Criminal Justice Response and Enhancement Advisory Council. One of the charges of this council is offender program standards and looking at the family violence education programs and the eligibility criteria. So this is obviously something that we will be looking at moving forward as well.
Look at that for timing on the 3-minute bell, huh? All right, let's start with Senator Kissel, followed by Representative Fishbein, followed by Representative Howard. We'll just keep on heading down the line that way.
Thank you very much, Chairman Staffstrom. Executive Director Scanlon, great to see you. Very honored to serve with you and all the other great experts and advocates and hard workers on the council. I know that myself and our tremendous Vice Chair, Senator Flexer, will be working real hard with the other members of this committee and our leadership, obviously, on these domestic violence matters. I think it's good. When I sat down with folks that had issues regarding the sexual assault matters, I said, reach out, because if you want to parallel them, if you can get their support on the DV side, that would be terrific. And obviously they did. And I think there's a lot of very unfortunate parallels, but there's certainly significant ones. So I think there's a lot of things that we can work on in a very positive way to keep us in a leadership role nationally, even though we have a short session. And I just want to thank you yourself for your tremendous leadership in the domestic violence area. And thank you for that service. Thank you, Chairman Stafford.
Representative Fishbein.
Thank you, Mr. Chairman. Well, since we're here to deal with language, I'd like to talk about the language before us. And 359, in line 6, what is the term what is it meant by the term provide needed resources?
So what I think the proponents of the bill are trying to get at is there are multiple ways to get at guardianship and custody, one being through the probate system and one being through the juvenile court. And so I think what they are trying to get at is to provide all of that information upfront to any individual that might be interested in seeking custody or guardianship.
So you're saying that that language has no particular value because the rest of the bill has to do with, you know, finding out who people are, giving them information about guardianship. And I'm just, you know, when I see provide needed resources, I'm thinking, you know, somebody's hungry, you have to go buy them a sandwich. It's raining outside, you have to go get them an umbrella. Those are needed, you know, provide needed resources. And somebody chose to put that clause there. So
Yeah, so right now there are intimate partner violence specialists within the Department of Children and Families that are assigned to specific cases. That when the IPV specialist is assigned, it's specifically stated to be assigned to the deceased grandparents. So in that initial time frame, that IPV specialist is going to be providing necessary resources to the family who's experienced the homicide. So that is something that Department of Children and Families would be able to give you details on, as I'm not fully aware of everything that they're going to go through with the individual, but that would be a question for the Department of Children and Families.
okay, so that phrase appears in line 6, and then in line 13, we once again, it says, now we are constraining a third party within 7 days to provide needed resources to the relatives of the deceased parent. So is it the same answer with it? Because I'm just trying to.
It would be this similar answer. Again, this isn't necessarily a CCADV bill, but we're just supportive of it. But I do believe it would be a similar answer that whatever those resources would be identified by the IPV specialist and then worked and coordinated with through the IPV specialist with the family members.
No, I got that, but that's all dealt with in lines 14 through 28. You agree? I mean, we
yes.
identify who the relatives of these kids are. We get information to those relatives about the process to apply for guardianship.
Right.
If you need a license, all that stuff, that's dealt with. And that's why I got a question. Why do we need this phrase in the beginning part that we've said it twice now? We don't define it, but I think I got your answer. And then the last part, lines 29 through 33, why would it be appropriate, and I'll read it to you.
Sure.
For the 30-day period following the date of death of a deceased parent, the commissioner shall not investigate any action in the Superior Court for juvenile matters concerning the custody of the child or children of the deceased parent. So kid is found on the side of the road, police go to the home of the child, they find it's a murder-suicide. We now have a child in DCF's care. This language would prevent them from getting an order of custody, correct?
I think the language is meant to allow for time for the family members to explore their options of either going through probate and avoiding juvenile court. I think that is the intent, is that there would be an option to say, hey, we want to pursue guardianship through the probate court, and we don't want to have to go through the juvenile system.
But in the meantime, we have a child who was found on the side of the road. The family wasn't there. DCF, under the rest of this language, is charged with trying to ascertain if this kid has any parents.
Right.
Or, well, the parents more than likely are passed, but let's say
Yeah.
a grandparent, an aunt or something like that, right? So now that doesn't happen by osmosis. There's got to be some sort of, something's got to happen with this little innocent child, right? And this language bars them from going to court to get an order. So how does that work in our system?
I don't believe it's meant to bar them from going to court. I believe that it's meant to, if they are able to identify deceased grandparents and all other next of kin, that it gives all of those individuals that may be interested or wanting to seek guardianship or custody a little bit more time to hopefully make a decision about, okay, the best process may be through probate court and not necessarily through juvenile. If obviously they can't identify somebody, then obviously they're going to start the juvenile court proceedings. But I think in this instance, I think the intent of the bill, and certainly the proponent, Senator Sampson and Representative Nuccio, I think their intent was to allow some more time and education for the next of kin.
Does anybody who's a proponent on this have any knowledge about the DCF process?
I think you'd have to ask the proponents of the bill.
Okay, because in my experience, DCF gets some sort of emergency order and any party can then say, they can put it for foster care, they can move to change that order. But in the meantime, I've got a child. Thank you.
I know, at least if this helps to clarify, I know at least in one of the instances, there's the homicide, the individual, the minor child was put into the grandparents' custody of the deceased. The only other next of kin that was interested in custody happened to be being investigated as essentially aiding in the murder of the individual's mother. So it was the brother of the offender. And I think the issue became that there was no communication or education from DCF around the different systems that the grandparents could have gone through in order to attain custody. So now that individual case is in the juvenile system, when I think what the grandparents would argue is that they would have preferred to go through the probate court system, because now they're not the only people that are being considered for custody.
And there could be concurrent jurisdiction in those cases, and DCF, as part of that process, would be able to opine, because certainly DCF gets involved with cases in probate court dealing with custody of kids, as well as the Superior Court. They are there for that. The other bill I wanted to ask you about is 5326, having to do with restraining orders. And, I do these cases frequently. And you said that this brought clarity.
Yes.
So I'm trying to, and I think you specifically talked about lines 13 through 17.
So the clarity happens in, starts in lines 9 to about 13. It just sets some clear standards for both the court and the protected party from the restraining order.
All right, so we'll work through that language together.
Yeah.
It says this, so these are things that a court is supposed to look, there's already a restraining order in place. A motion is filed to perhaps extend that restraining order.
Yep.
And matter comes before the court because they couldn't resolve it in family relations. And what does the court have to look at? Okay, so that's what this does. So it says the severity of the initial grounds for such order, the ongoing impact on the applicant, the respondent's adherence to the provisions of any existing restraining order, or new or ongoing behavior on the part of the respondent that meets the criteria of domestic violence. That's that clarifying language.
Right.
But then it goes on to say, the fact that the respondent has not engaged in acts that constitute domestic violence, as defined in 46B1, during the pendency of order shall not in itself constitute sufficient grounds for denying or failing to extend the order, for allowing the order to expire or be vacated, or for refusing to issue a new order. So you get a situation where restraining order is issued and perhaps it's concurrent with an arrest, right? There's breach or an assault. Case goes to family relations. There's a criminal protective order, there's a family violence restraining order in place concurrently. The defendant, respondent attends family violence education. They learn what they did was wrong, that, that is domestic violence. So now the criminal case is, let's say, dismissed, successful completion of the family violence education program. All we have left is the restraining order. The applicant files a motion to continue that restraining order for another period of time. The fact that the respondent was good, has learned, has not committed any acts, would not be a bar, or essentially would be, would preclude a court from not extending that restraining order. That's what this language says?
So we are just asking that it not be the sole decision-making factor in denying an extension. So that could very well be the case, but we're asking the court to not solely base it on the fact that during that period of time, there was no violation, because we know full well that individuals can be still trying to relocate, or that individual is only not perpetrating the behavior because the order is in place. So we want to make the option for victims to be able to extend that based on their feelings of the abuse not dissipating. They still remain afraid. This law was instated before even the definition of coercive control. So there's other factors that I think have to be considered outside of just non-physical abuse, like financial or other emotional, psychological things that could still be going on. So we're not saying that we're not saying that a judge could deny the extension. We are just asking that it not just be based on during that time that the restraining order was in place, that be the only deciding factor.
Okay, so where are the due process rights of the respondent in that case? We have an initial restraining order based upon an affidavit, perhaps it's an ex parte order. There's a hearing on that. It's established at that time that it meets the level of 46B15.
Yep.
Restraining order issues. Now there's going to be a hearing, let's say a year later, right? And the respondent has been good. They've done everything, the court is, but they have no notice that all this other stuff is going to be presented to them at that hearing. How do I deal with the due process concerns?
I mean, I think they would be able to respond to that. I think what we are just solely asking for is that the individual, so I think what this bill does is it clarifies for the individual that has the restraining order, right? The protected party. It clarifies for them the standard that they have to go into court with in terms of requesting an extension. I think right now what happens is you go into a certain court and there's no sort of set standard across the court system. So we're trying to clarify that in this bill. And then second, we're not suggesting that the defendant doesn't have the ability to say I was on good behavior and all of these things. We're just asking that there be other factors that are listed in lines 9 through 13 that be considered, and that one factor not be the sole consideration, because we know that abusers can not violate for the time, and then once it's lifted, they go right back to the behavior. And we see that often, if not daily, in the work that we do. We also know that individuals may be in the process of relocating and just want the extension so that they can relocate. I would argue they shouldn't have to relocate. They should just be able to get the extension of the restraining order and be able to live where they've originally been living. But the reality is a lot of people have to relocate because they don't get these extensions and they're still afraid.
So my question had to do with due process. So our courts, especially our Supreme and Appellate Court, are pretty strong on due process. And when you go to court, having the right to face your accuser and to perhaps, diffuse the allegations. And for that reason, we have the affidavit process where somebody going to their initial hearing knows what they have to disprove, right? So I'm dealing with, and what you're dealing with this legislation is dealing with, is the back end. right?
Mhm.
Now you've had the hearing, the order has been issued, and now it's whether or not to continue the order. But the respondent who is not doing, we're going to assume, anything bad physically, you just said that we can bring up coercive control elements that were never mentioned in the original application at this new hearing, that would be appropriate under this language. And I'm just trying to get
Yeah.
to the, how, because I do both sides of these
Yeah.
cases quite frequently.
I am not saying you can bring it up like I'm just saying we didn't have the coercive control statute with the original statute, and we obviously have that now. So there can be behaviors that are non-physical in nature that are happening even during that time of that restraining order that I think are relevant for the protected party to be able to bring up in court if they are happening. So that was my only clarification there.
Yeah, as a practitioner, I have severe concerns about lines 9 through 13. Because they have really nothing to do with bad acts, except for the last part, which actually sort of nullifies lines 13 through 17. That part says new or ongoing behavior on the part of the respondent that meets the criteria of domestic violence. So
Right.
certainly that is relevant, right? Because
Yeah.
that's akin to a violation,
Right.
right? But then in the very next sentence, you say, if there isn't a violation, you can't solely rely upon that. So that the two nullify each other there. I'm concerned about the severity of the initial application. Okay, yes, the bad stuff happened, right?
Mhm.
But it's not happening now. It might have been severe.
Yeah.
He may have done something, usually it's a he. I'll concede that,
That's
right?
correct. Yeah.
There could have been a significant event, but through our diversionary programs, whatever, he has learned that you don't do that stuff. You don't touch people unwanted and that kind of stuff. But the severity under your language is going to be part of that continuation hearing. And
Right.
I got trouble with that. So thank you, Mr. Chairman.
Representative Howard.
Thank you, Mr. Chairman. Hi, Megan. Thank you
Hi.
so much for being here. I just want to talk to you briefly about 5418.
Sure.
Shocker, right? But can you just, for the members of the committee who may not be familiar, can you just talk briefly about what the pretrial family violence education program is? Because this bill would extend eligibility for offenders to participate, right?
Correct. Yeah. So it's a program that is offered through our court system that allows offenders to participate in a series of education programs over a period of time that help to teach them essentially like to recognize their behavior, to help them cope with their own trauma, to be able to then hopefully change their behavior over time using healthy coping mechanisms. So it's been obviously successful for many offenders. And so we obviously encourage the use of it and want to get as many people into the program that are eligible to be able to be in that program, because it does ultimately get to the outcome that we would like to see. Most of the individuals that we work with just want the abuse to stop. They don't necessarily want to be cut off from their family member or intimate partner for life. So we obviously encourage the use of the program and think that this is a good way of allowing more people to participate in the program, and also allows law enforcement the ability to at least recognize the significance of performing an act of domestic violence in front of a child. We know that is, it increases the risk factors over time that child will perpetuate that violence. So we want to make sure that is noted, though, on their record.
So basically right now, under our current statutes, if an offender, dominant aggressor, commits a crime of family violence in the presence of a person under 16, that individual should be charged with risk of injury now, right?
Right. Right now it's a felony.
Right. And this won't change that at all.
No.
All it would do. So currently, if that happens, where somebody strikes say their spouse and gets arrested and a child witnessed this and the officer correctly charges, say, assault, third, and risk of injury, that individual is now precluded from participating in family violence and getting to that root cause and getting that education, right?
In most cases, correct.
Right.
Yeah.
So what we're doing is we're saying in those particular cases, when good cause is shown that this individual would benefit from family violence diversion in the education program, even though that risk of injury charge exists and is there, they can still participate, right?
Correct.
Okay. And I just want to thank you and CCADV. We've engaged a lot on this prior to today, and I'm greatly appreciative. In fact, we have achieved something that's the first time I've seen in 3 years. We have testimony in favor of this from the Chief Public Defender's Office, as well as the Chief State's Attorney's Office. And I don't think I've seen a bill like that in 3 years. So we can hang our hats on that. Thanks so much for your help, and thanks for being here today.
Thank you very much.
That's not true, Representative. Oftentimes our criminal aircraft carrier is supported by both. Representative Osborne.
Thank you, Mr. Chair, and thank you for being here, Ms. Scanlon. And thank you for the work that you and your organization do to keep victims of domestic violence and their children safe. Returning to 5326.
Yeah.
So the standard on granting, as you know, a initial restraining order is whether it's necessary to maintain the safety and basic needs of the applicant. And on the current standard for the motion to extend, and by the way, so these cannot be extended absent a motion of the applicant.
Correct.
So the applicant's already coming to the court and saying that they feel that there is a need for this to happen. And under current case law, correct me if I'm wrong, current case law that controls on this issue at the appellate level was decided before coercive control was a criteria on which a restraining order could be granted. That's correct.
Correct.
So any of the existing case law talks about the need for ongoing threat because coercive control and the impact of coercive control were not criteria that a court could consider. But when we talk about the basic needs and safety of the applicant, nowadays we're talking about her need for emotional safety and psychological safety as well. Even though the current case law that controls on the motions to extend does not consider that criteria. So when you're looking at the impact on the applicant, you're talking about, some of your clients are seeking to relocate.
Yeah.
That's likely because they are still in fear of the respondent. So no matter how good or potentially rehabilitated the respondent may or may not be, the applicant is still experiencing fear, trauma that's being triggered at the very thought of having to have contact with this person. So regardless of how well behaved a respondent may have been, their initial actions have been such that they have traumatized the victim who experiences this ongoing impact. And I'm sure, as you know, in the line of work that you do, trauma really can't be healed if it's exposed over and over and over again to the trauma. So trauma victims need space. They need not to be exposed to the initial trauma in order to heal that. So in order to maintain the basic needs and safety, trauma victims in particular need to have that space. So wouldn't you agree that allowing a court to consider, which they don't under the current case law, the ongoing impact on the victim, and doesn't that actually hold the respondent actually responsible for the consequences of their actions, regardless how long that consequence may take to ameliorate?
Yes.
Okay. And with respect to due process and notice, and I know you don't practice in court, but like
No, I don't.
Representative Fishbein, I practice in court every day, and I do both sides of these applications as well. And as you know, I'm sure, having supported clients who do go to court and do have to appear before a court to ask them, to protect not just their physical safety, but their emotional and mental well-being as well. The practice book and the standing orders of compliance, they're there for those due process reasons, right? You have to file under the current standard, you have to file a motion that puts the respondent on notice that you want the extension. And then 5 days before the actual hearing, standing order compliance has to be filed. Your exhibits have to be uploaded to the judicial website. You have to put together your proposed orders. You have to put together the list of your exhibits. All of that has to be exchanged with your opponent and opposing party, opposing counsel, if there is any, 5 days ahead of time. So wouldn't you agree that, I know you're not an attorney or a
I'm not an
constitutional
attorney.
expert, but that sounds like due process and notice to me. Wouldn't you agree?
I mean, CCADV would argue yes.
Thank you very much. Thank you, Mr. Chair.
Further questions or comments? Further questions or comments? Seeing none. Thanks for being with us.
Thank you very much.
Kristen Harmeling.
Yes, good morning. Thank you so much for allowing me the opportunity to speak today. I am dialing in from Seymour, Connecticut, where I am currently a vice president of a market research firm, and I also am a 12-year member of my local board of education. I'd like to speak today in support of House Bill 5420, an act concerning the provision of child support to children aged 21. When I became divorced in 2017, at the time I had 14-year-old twins and an 11-year-old son. And things went fairly smoothly until my two children aged out of the system. And it caught me by surprise. Perhaps it shouldn't have, but it did. And it occurred to me when I was notified that I would not be receiving child support for my 18-year-old twins that I wasn't really sure what made them less expensive in the month of August than they had been in the month of July. So I have read the testimony that's been submitted, and I so appreciate my state representative, Nicole Claridis-Ditria, for supporting this bill. I've also read comments about that this needs to be studied by a task force. I would implore the committee and the full House to not hold back on moving forward with this. Providing child support through the age of 21 is something that our surrounding states already do and have been doing for quite a number of years. Massachusetts and New York both provide for child support through the age of 21. There's an undue burden being placed in the state of Connecticut on custodial parents, and these issues have really been compounded over the past few years due to the unprecedented level of inflation among today's generation of parents, because child support does not increase with the cost of living. So what you're assigned is what you get, and then your children age out and you are left continuing as a custodial parent to raise these children that both parents love, but I'm just not sure why the burden is placed on one parent to continue providing support and not the other. So should this bill become law, child support would be paid to the parent who is supporting the child in the exact same way it is being paid now before the child turns 18. I did notice that in other testimony, there was concern about what does this mean for a child? And I would just put forth to this committee that it means the same exact thing, that child support means when a child is 17 or when they're 18 and still in school. So in closing, especially in a state like Connecticut, one of the most expensive in the nation, where extremely few of our 18 to 21-year-olds are financially independent and living in their own, this really feels like a common sense bill that eases the financial burden and also helps protect the financial future of custodial parents. And again, I thank you for your time.
Thank you. Questions or comments from the committee? Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon, ma'am. Oh, no, it's still morning. Thank you for coming here today. You were telling us about your personal experience.
Yes.
Were you represented by an attorney, or did you represent yourself in your matter?
We used a mediator. So I guess technically I represented myself, but I did have my paperwork reviewed by an independent attorney.
Okay, because part of your testimony, you indicated that you did not know that child support was not like into the infinity, or
no, I certainly did not expect it to be for infinity, but because I had two 14-year-olds and one 11-year-old, The wording, the paperwork that was provided and developed by the mediator said that child support would continue until the last child turned 18 years old. And so I took that at face value and interpreted it like a layperson would. And so I felt that, okay, at least I'll be getting child support through when my twins turn almost 21 and when my youngest son turned 18. And then I learned as the time approached where my twins were turning 18, that was not the case. And I did consult with several different attorneys, and I tried to say, well, I'm not really sure how else this language could be described. It truly says child support will continue until the last child is 18. And then I was told, yes, but that only applies for that last child. So that was a misunderstanding that quite honestly, I don't really blame myself for making, because the language seemed clear to me, but the intent of it was not what I had assumed it was.
Okay, understood. I'm looking at the language, particularly lines 18 and 19. And I don't mean this, I just I think it's helpful. Are you an attorney?
No, I have not.
Okay. If we could just walk through this together. So it requires that the child, well, at this point in our scenario, they're not a child anymore, right? They're over the age of 18. They're less than 21, is domiciled in the home of a parent, right? And is in need of maintenance. So, you know, when I read that, you know, adult children sometimes go live somewhere else temporarily. I mean, especially that age. If they're at school, let's say,
Yeah.
would the child support still get paid under this language?
The child support would still get paid under the language, because even when a child is away at school, they are home about 4 months of the year, and that child still needs a room to come back to. Even if it's a shared room, they still need a home to come back to. They still need to eat while they're home and dry their hair when they're home and take showers when they're home. So I would say yes, and if there's a simple way to kind of reduce that while the child is at school, I get that. But also when we talk about parents splitting their college expenses, if a student decides to stay home and go to a community college, which is blessedly free, but if they were to go home and be a commuter at one of our state universities, there is nothing that is provided for that custodial parent, and that child might be there for every day of the year.
But even absent this language, you know, parents that are getting divorced could agree to all of this stuff absent the legislature stepping in.
But it is not able to be compelled by the court. That was made very, very clear to me when I was asking the same questions. You can absolutely write the intent into the divorce decree, but it is not something that you can take to court and make happen. The court will not compel the person to agree with what was agreed to in principle on paper.
I don't
There is no
necessarily
recourse.
that if it's a judgment of the court, it's enforceable. If you went to trial, a judge would not have the ability to order this, but certainly
Right.
intelligent individuals and a settlement agreement could agree to something like this. So
Right, but I'm sorry to interrupt, but if it's not enforceable in a court of law, then
I believe it is enforceable. So
I was advised that it was not enforceable, that I could not go back and say, I would like for you to follow the letter of the intent. And right in the divorce decree, it says it is not something that can be argued in court. So
sure.
a little bit of a difference
The example I'll give you, ma'am, is October 1 of 2001. The legislature passed a law that had to do with the child support, with college, post-secondary educational
Yes.
expense, 46B, 56C.
Yes.
Prior to that, I was in court regularly, and parties were permitted to contract to that in their settlement agreement, even though it wasn't the law and it was enforceable. So this is a very similar situation to that. So I will say to you, I believe it is enforceable if it is in the decree when the parties get divorced. The other clause that I wanted to ask you about in
Mhm.
line 19, in addition to being domiciled in the home of the parent, we have this clause that says, and is in need of maintenance.
Mhm.
So what is the calculation for an adult determining that they are in need of maintenance?
I don't know that it would be any different from a 16 or 17-year-old. And when we look at things like the FAFSA, there are some pretty clear litmus tests, if you will. If a child under 21 is married, no, they are not a child in need of support. If they are in the military, they're not a child needing support. And if they are in the military, they are also not a child in need of support.
Okay, so if the 19-year-old is, let's say, working
Mhm.
outside of the home, but they're domiciled and they're working part-time,
Mhm.
would the child support still be there?
It would, just like it was if they were working when they were 15, 16, or 17.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments of this witness? Further questions or comments? Seeing none. Oh, Representative Osborne.
Thank you, Mr. Chair, and thank you so much for being here today and
Thank you.
sharing is our witness still here? Do we still have our?
Yes, yes,
Oh,
I'm here.
great. Hi.
Thank you.
Thank you so much for testifying today and sharing with us your experience as a custodial parent once your kids age out of child support.
Mhm.
And I think you said it exactly right. Your children aren't any less expensive in August than they were in July, and they are still your children. And I want to be really clear that there are plenty of good, noble, honorable, non-custodial parents who are more than happy to provide support for their children after they turn the age of 18. But you're very right that in this moment in time, there is nothing that the state of Connecticut can do to require that a non-custodial parent agree in a divorce agreement to do so. And there is nothing that they can do to require that after that child ages out of child support, they provide 1 red cent
Mhm.
for the assistance or support of their child. And I've read some of the other testimony here today that suggests that if that if there is an estrangement in that relationship, it must be the fault or contribution of the prior custodial parent. And we all know that reasons for estrangement between parents and children in divorce are incredibly complex and varied. And so thank you very much for your testimony. And that's all. Thanks for being here today.
Thank you. I really appreciate it.
Further questions or comments? Further questions or comments? Seeing none. Thanks for being with us.
Okay, thank you so much.
I understand that Michelle FICA is not with us, so next we'll move on to Beth Hamilton.
Good morning and happy birthday, Senator Winfield. Good morning, Representative Safstrom, Senator Kissel, and Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for the opportunity to share support of a number of bills this morning. I'm going to focus on 2 of them. My name is Beth Hamilton, and I am the Executive Director of the Connecticut Alliance to End Sexual Violence. The Alliance is the state's coalition of community-based sexual assault crisis service centers who provide 24/7, 365 crisis interventions, including hotline services, counseling, support groups, accompaniments in hospital, police, and court settings, and advocacy and legal services while navigating complex systems-based processes. HB 5298 will allow those who cause harm to be held accountable for the entirety of their actions. The Connecticut State Supreme Court decision in State v. Douglas C. and State v. Joseph V. Interpreted our state's sexual assault statutes as criminalizing only individual acts of sexual assault, not a continuous course of conduct. This is particularly impactful for child abuse cases involving the ongoing abuse of children. In these cases, the burden is currently placed on children to be able to differentiate between individual instances of forced sexual contact or forced sexual intercourse perpetrated against the child. Child sexual abuse is incredibly common in our society. In the US, approximately 1 in 4 girls and 1 in 13 boys will experience sexual violence before blowing out their candles on their 18th birthday cake. And nearly half of all females who experience rape first did so before the age of 18. It is critical that prosecutors be given the tools to adequately address child sexual abuse. One of my colleagues, Special Assistant State's Attorney Stephen Sedensky, is also here to testify and will be able to answer any of your nuanced questions about HB 5298. The Alliance thanks the committee for raising HB 5414, which will provide protection from discrimination for all victims of sexual assault. Experienced sexual violence only gets more common the longer that we live. Over half of all women and almost 1 in 3 men will experience sexual violence in our lifetimes. Victims and survivors of sexual violence experience a significant emotional and physical burden in the aftermath of sexual assault that can impact every facet of our daily lives. Adding victims of sexual assault to Connecticut's list of protected classes will ensure that they have continued access to their jobs, homes, and financial security as they pursue healing, justice, and well-being. Currently, only victims of domestic violence are protected from discrimination in statute. HB 5414 will also support survivors who need to seek services and safety plan with a sexual assault advocate, allow survivors to attend court counseling and medical appointments, and support survivors who need to relocate or make changes to their housing to be safe. It also includes the creation of a 1-hour training for all state employees about sexual assault and the posting of information and resources available to victims. Employers can play a critical role in supporting victims of sexual assault in the workplace, and posting information about sexual assault resources is a simple and no-cost way to make survivors feel connected to their workplaces and increase the likelihood of seeking support. Before I leave, I also want to state that the Alliance supports HB 5421, and I want to acknowledge support of our sister coalition, the Connecticut Coalition, against domestic violence and their issues that were raised this morning. Thank you for your time this morning.
Thank you. Questions or comments from the committee? Questions or comments? If not, thanks for being with us. Kathy Kennedy. Representative Kennedy, is the person sitting next to you signed up to testify today?
I'm sorry,
Is the person sitting next to you signed up? To
this is my constituent Julie Nash. Is she signed up?
What number is she on the list?
What number? She's not sure.
Okay.
I'm going to yield my time to her.
No,
I
we
cannot.
don't allow that here. So you can testify, but if she's not signed up to testify, we can't allow her to testify. She can submit written testimony for sure, but.
She has submitted written
Okay,
testimony.
so if you'd
Okay.
like to comment, you can.
Thank you. Mr. Chairs Winfield and Stafstrom, Vice Chairs. Excuse me. Sorry. Vice Chairs. Sorry, you threw me off there because I thought you were on this. Anyways, I am here to testify in support of HB 5423 and that concerning fertility fraud. I have with me my constituent Julie Nash, who is recently was expressing her strong support for 5423, which seeks to prohibit physicians from knowingly using their own sperm. And I would suggest adding or fraudulently misrepresenting the donor without the patient's consent to inseminate or to create a cause of action against any physician who engages in such conduct. The use of a physician's own sperm or fraudulently misrepresenting a donor without the patient's knowledge or consent constitutes a grave betrayal of this trust. As someone who recently discovered that she is a donor conceived, but also a donor deceived about the identity of her biological father. Her testimony personally, and she's submitted in writing, attests to the effects of such deception on her and her family. In her case, her mother was assumed that she was undergoing insemination with sperm from a young Yale medical student who was medically cleared. However, the reality was far from the truth. It was later revealed that the sperm used belonged to a 45-year-old fellow doctor who tragically passed away at the age of 59 from colon cancer. She's one of the lucky ones that discovered this medical history. Her mother was seeking alternative ideas to bring a child into the world when she was referred to a fertility physician informed of an emerging practice. In order to participate, she was asked to come after hours with cash, and no records were kept of the insemination. She was assured it was a young, medically cleared young Yale med student that would match her father's look. They took advantage of a young woman desperate for a baby. She struggled to find the cash for multiple inseminations and handed it over in a plain white envelope after hours like a street transaction. This lack of transparency and accountability only added to the shame and secrecy that her mother carried throughout her life. We have since discovered that there are 21 of us date, but we anticipate more. The deception surrounding the real identity and medical history of the donor had far-reaching consequences for both her family, herself, and many others. I would also like to bring to your attention Public Act 75-233 concerning the status of children conceived through artificial insemination. The act requires doctors to file certain information with the judge of probate and when a child was born through artificial insemination. The Public Act was repealed in 2020, leaving a gap in oversight and accountability and assisted reproduction practices. She's tried to retrieve that information from the probate court, and I know my time is up, but if I could just finish, and there are no records. Really important, there are no records. Where are they? Who asked for the repeal of this Public Act? And there needs to be a place for her and others like her who have just recently discovered this information. I thank you for your time and happy to answer any questions if I can. Thank you.
Thank you, Representative. We appreciate being here and certainly sharing your constituent story with us. Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon,
Thank you, sir.
Representative Kennedy. 5723, that's not like before us today, right?
No, it is not.
Okay. I'm just trying to get is that before some other committee or is it?
That was Public Act 75, I may have said it wrong, 75-233.
Okay.
So it's a while ago.
Yeah, okay, so
long time
that's,
ago.
okay, so I want to stay on 5423. And, when I was reviewing this, it's very short language. Why would, obviously, anybody putting something in somebody else's body without their consent, bad, right? So let's just start there. But why would we just make this directed to physicians? Because somebody could have been a physician, they could have lost their license, right? But they're out there saying, I'll do this for you for a fee, right? So are you okay if we change no person?
No, that's a very good point, Representative Fishbein, and I would actually leave that to the committee's purview to change the language to reflect anyone. Because you're right, it could just be some type of fertility clinic that it's just, I don't know what that person is.
Yeah, okay.
So absolutely, yes, we'd be open to that, absolutely.
So then we aren't saying that this is a crime. It should be, right? If it's not, it should be, okay? We're dealing with civil liability here. So I'm looking at the scenario, one who has the ability to bear a child, wants to bear a child. So they look to someone to commit an act to allow them to have a child. I mean, I think the word that you use is desperately wanted a child, right?
Correct.
So that is the fundamental, the ground here. When I look at the next part, so you put this substance in someone who desperately wants a child. And let's just say a child results. We are permitting the person who now got their desperately desired child to sue. And my thought was, what are the damages? So now it's probably going to be a statute of limitations limited suit, right? So within 2 years, you're going to have to bring a civil action, it's not a criminal action, against this individual who, without them, you wouldn't have a baby, right? And you have no idea what this child, they could be a concert violinist, they could be a famous painter, they could be a famous sports star. How is a jury to determine damages?
That's a good question. I think a big part of it is the transparency of the whole transaction. This woman was led to believe that she was going to be inseminated by a young medical student and not a 45-year-old man, and she wouldn't have consented. You'll hear other testimony from many people behind me that have experienced the same situation. They're all signed up. And so that is, but it's the transparency of the transaction, and it's preventing it from going forward, because I would suspect that there's going to be other actions or other people who may come to realize that this has happened to them.
But and maybe you're arguing that it should be a crime, right? You don't want this person to do this to someone else. You want them to go to jail because they did bad, right? But ultimately, if it's a civil action, you've got the mother now, right? Because she's born a child, the desperately needed child. Her lawyer is arguing to the jury, you should give her money because she got the desperately needed child. And the defense is saying, well, it's unquantifiable because she got the desperately needed child. We're not in the criminal sphere, we're in the civil sphere. So I'm just trying to figure out how is that done? I mean, because the language is recover the actual damages sustained by such person. So there you would have, the hospital stay, right? But and recuperation and, maybe time off from work. But the defense is arguing she got the desperately needed child, right? And it's still a baby basically, because, cases filed within 2 years, you're going to have a trial within another 2 years later. So let's just say at the most, I've got a 4-year-old kid that could be the most brilliant kid in the world, right? But we don't know. That could be a traumatizing experience for the plaintiff, for instance, because they want the closure because they were violated, right? But once again, we're in the civil sphere and not the criminal sphere. So that's, once again, and I will flag, we don't usually just give attorney's fees. We usually, permit a court discretion to do attorney's fees, which usually opens up the door to, what if you make the allegation civilly and you can't prove it, should the other party be entitled to their attorney's fees also, if for whatever reason, should the court, and that's usually the way I fall, because I try and be equal. So I know there's a lot of stuff. Do you want to respond?
I do, Representative. I thank you for that. So I would liken it to a case where when you go in for, let's say, knee surgery, and they'll put an X on your left knee, knowing that that's the knee that they're going to do surgery on, but they accidentally do surgery on your right knee instead of your left knee. I think that would come into play in somewhat of what I believe that you're saying, and that to me is negligence on the part of the doctor if they've performed, or they go in for an appendectomy, or you go in for an appendectomy and they snip your colon by accident.
Maybe
I mean,
that's
is
totally
that just
that's totally different though. I mean, if they take off the wrong leg, yes, that is malpractice, or they operate on the wrong leg and you had a perfectly good right knee and they operate on the right knee anyway, and really it's still a good right knee, you got a bad left knee.
Right.
But the scenario here, and I can see it. I can see the tall, defense attorney, polished shoes and nice tailored jacket, before the jury saying she got what she wanted. She got the baby that she desperately wanted. She's not entitled to anything. I mean, I've sat in on so I'm really wrestling with this damages calculation here. So, because it's totally different than malpractice. And I don't even think this is structured as malpractice.
It's not. So I would just go back to it, if you allow me. It
Yeah.
still comes down to misrepresentation. And yes, desperately wanted a baby. So any woman that is having trouble conceiving, obviously, and they really want to have a baby, and has that baby has a wonderful life, blah, blah, blah. But then only to find out many, many years later that you're not the product of what you thought you were. And then you find out perhaps that you have siblings that you never even knew existed. Your whole family has been shaken, and explaining that to your spouse, your children, where you are when you look at the ancestry list, I guess, if you will.
But that scenario is the child bringing an action, right?
So that would be-
Right? And this wouldn't happen under this language because we don't allow 4-year-old kids to bring actions in court, right?
Right.
So the language we have before us, now maybe there's a different way to deal with this, right? Maybe you require all of these things to have a contract. And you have to expressly state, who the donor is. And, have them give a copy of, I don't know, ancestry.com or whatever. so you know where the person came from. Maybe that's the way to deal with it, which is probably a public health issue. I'm just trying to wrestle with what we got here. So I don't want to pass a law and tell people you're going to have remedy here when I don't really see it through this, but
And I thank you for all the questions. The only just last thing I'd just say is I still think it comes down to consent, and was the right consent given at the time that the procedure was performed. And I think that's where my constituent would hold the most. That
and if it's not a
consent and
crime,
transparency.
if it's not a crime, I'll sign off on it being a crime, right?
Thank you, sir.
But different realm. So thank you, Mr. Chairman.
Thank you. Thank you, Mr. Chairman.
Hold on 1 second,
Yes, sir.
Representative. There's a question from Senator Lesser.
Yes, thank you, Mr. Chairman. And I have a question just sort of along the lines of what I understood Representative Fishbein to be asking about. I understand what you're trying to do here, Representative, is create a new cause of action going forward. Obviously, you have a constituent who's been harmed. I do too. And my understanding is the bill mentions the fact that there may be other claims that are that could go through the judicial system under existing causes of action. The bill does not currently toll the statute of limitations and I'm imagining there are a number of folks who might be up against statute of limitations issues. Is that something that you have thought about or would support adding to the bill
I believe
to allow
that-
people? Yeah.
I'm sorry, sir. Yes, I believe, sir, that would be something that would be supported, certainly.
Okay, for folks who have existing claims,
Right.
but not obviously you're not looking to create this new claim retroactively, but for folks who have existing claims, but it may be just recently discovered that they were the victims of this kind of thing.
I think these are mostly recently discovered cases. And yes, you're correct. There are several other cases that are possibly within the judicial system at this point.
Okay. Thank you for your answer. And thank you, Mr. Chairman.
Thank you, sir.
Thank you, Senator, and thank you, Representative, for being with us.
Thank you,
Appreciate it.
Representative. Have a good day, everybody.
You too. Next up, we have Matthew Brodacki.
Yes. Good afternoon, House members and legislators who might be in attendance, as well as public members. My name is Matthew Brodacki. I come before the House to submit a record of testimony in favor of Bill 5421. I make the statements as a father, husband, and member of a regional cyber crime unit. As a police captain, we handle approximately 500 cases a year. Many members of our cyber crime unit are deputized by the United States Secret Service, and I have 24 and a half years of law enforcement experience. The law as we know it is to establish healthy boundaries. Currently, with little or no technical skills, someone can open artificial intelligence software and ask it by typing in the search bar to generate images or videos with a typed description for the action, and the computer can perform the task so well that it may be difficult for a reasonable person to tell if a person is real or for a computer-generated image. And that computer-generated synthetic reality was created only by one's imagination and words that were typed into a search bar. If a person with nefarious intentions commits a film of a violent sex assault of a child and opens the artificial intelligence software with simple instructions to change the known human faces that capture the suspect and victim's face to unknown synthetic reality faces, making it very difficult to get arrested and prosecuted for the sexual assault, that is a reality in 2024 that we're already looking at. Conversely, another bad actor can do the opposite with the faces and the uploads of a real family photo, and then ask the AI software in plain English to simply switch the faces in a child exploitation video they possess to those members from the family photo, essentially creating a violent sex assault of others using their own faces to share or grow closer to some fantasy. So the easiest way I always explain it to non-technical folks who might be in the crowd is software is essentially the instructions and the hardware performs the actions. While artificial intelligence has been utilized for decades, the instructions or software required a high level of technical ability. Whereas now in 2024, we have to ameliorate a number of problems, which I think are going to propagate to a number of different statutes. And I can reference those quickly as well before I get off. But the software no longer requires a high level of skill, just the ability for someone to type in plain English a set of commands to accomplish synthetic reality. In fact, Channel 1 News AI is going live for those who have access to YouTube, just to see what a synthetic reality person looks like and really evaluate for yourself, and ask those questions if they're discernible, whether they're a real human or a computer generated person. I'd also just like to close. I have a great appreciation for the lawmakers of the state of Connecticut and for the consideration of the House on this rapidly evolving technical topic and the statutes that I think that these also propagate to. So we're talking about Bill 5421, especially lines 5, 6, and 7. But I think that these also refer specifically to sexual assault 53A-73A, an act concerning child pornography 53A-196 Delta, D as in Delta,
So you're
and 53A21.
Thank you.
Yep. Thanks.
Questions or comments from the committee? Questions or comments? Seeing none, appreciate you being with us today.
Thank you.
Next up will be Talisa Brown.
Thank you. Yes, hi. My name's Talisa Brown. I am a staff attorney at New Haven Legal Assistance in the Family Unit. I'm testifying for New Haven Legal Assistance and Connecticut Legal Services regarding House Bill 5420 and House Bill 5326. Regarding House Bill 5420 on increasing the age for child support to 21, we believe the bill should be converted to a study or working group. We understand that young adults may struggle to be self-supporting. However, we do have some concerns about possible collateral consequences of the bill. We worry about child support to age 21, possibly implying a visitation right to age 21. We worry about the bill's possible impact on an 18 to 21-year-old who's trying to apply for and receive public benefits. Generally, we worry about the implication for young adults' autonomy. For example, what will it mean if child support is being received by the parent instead of going to the child? The child's now an adult, but will that parent have control over the young adult's expenses because they're getting the money? We also have a specific concern about the bill's interaction with immigration law. Special immigrant juvenile status allows non-citizen youth under age 21 to apply for lawful permanent resident status. And as it's been explained to me, and as I understand it, this process often involves going to probate court and seeking a guardian to be appointed for an immigrant between the ages of 18 and 21. And we have some concerns that a probate court might not find it appropriate to appoint a guardian if there's someone out there who still has a legal obligation to provide support to that 18 to 21-year-old. And we're afraid that might have some impact on ability to get that relief. So in sum, on Bill 5420, we think a study or working group is needed. Regarding Bill 5326, we're strongly in favor. This bill would give needed guidance to judges who are considering whether to extend a restraining order. As it is now, judges have very little statutory guidance on whether to extend a restraining order, and it's led to a norm of judges denying restraining orders unless there were violations of the existing restraining order. Sorry, denying extensions unless there were violations on the existing restraining order. And this is a problem because many of our clients, they have endured horrible abuse, they get the restraining order, and actually the abuser is afraid of violating the restraining order. So in these cases, our clients, they still reasonably fear the abuser, but they believe that the restraining order has actually protected them, but they face this uphill battle when seeking an extension of that order. So that's why we support Bill 5326, because it instructs judges to consider not just whether there were violations, but also the severity of the abuse that led to the restraining order in the first place and the ongoing impact on the applicant. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon. Next, we will hear from Marilee Hill. Good afternoon. Push the button in front of you. Make sure the microphone is on. Ma'am, there you go. Wanted to make sure your microphone was on. Begin now.
Pardon me?
You may begin now.
Okay. My name is Marilee Hill and I live in Weathersfield, Connecticut. And I'm speaking on Bill number 5423, an act concerning fertility fraud. I am Victoria Hill's mother and we are victims of fertility fraud. And I wholeheartedly support HB number 5423. My husband and I sought out fertility treatments after being told that it would be difficult to get pregnant in the conventional way. Dr. Burton Caldwell was recommended. Dr. Caldwell informed us that donors would be used and they would be residents from Yale New Haven Hospital who donated their sperm anonymously. He told us they were vetted for medical histories and that they would try and match basic characteristics of my husband. We started treatments in 75 and I became pregnant and gave birth to a baby boy in 1977. My son is not a Dr. Caldwell donor baby, but the result of a resident doctor. We sought more treatment from Dr. Caldwell in order to have another child, and I gave birth to a baby girl, Victoria, in 1985. Again, during that time, between 77 and 85, we were told that sperm donors were anonymous and there'd be no information available for us. Through DNA testing, we found out that Dr. Burton Caldwell was her biological father. It wasn't a resident from Yale. At that time, she was having health issues and wanted to get a medical history. And it was a shock for us to find out at that time that the doctor was the actual donor. And we trusted the doctors completely, never thought that he would betray his Hippocratic oath to do no harm and betray his patients. As of today, my daughter has 23 donor siblings and her children have 41 first cousins. We recently found out that a boy my daughter dated and had intimate relations with was her half brother, also donated by Dr. Caldwell. And this was extremely traumatic for her and myself. Because Dr. Caldwell was the go-to doctor in our area for artificial inseminations, as a result of DNA testing, we found out that there were many siblings in our area that my daughter had come in contact with and never realized were her half siblings. And this is extremely, this is a recipe for disaster that we're running across. She's running across her siblings and doesn't even know it because this doctor just went on and on with his donors. It is unconscionable that Dr. Caldwell can get away with doing the damage he has done to people without their knowledge and without paying any consequences. That is why.
If you could just summarize.
Pardon me?
If you could summarize, you don't have to stop, period.
Okay. And that's why I strongly believe in this bill. And then there has to be some protection for unsuspecting patients to know that they can trust in the process. We need to stop illicit inseminations. And I think we're entitled to compensatory and punitive damages, attorney's fees, and also entitled to medical records and medical histories. And have the statute of limitations dismissed and be retroactive to the date of when the fraud was committed.
Thank you.
Thank you.
Comments or questions, members of the committee? Comment or question, Representative Porter.
Thank you, Mr. Chair, and I don't have any questions. Hi.
Hi.
I just wanted to thank you for coming in today and sharing your story with us. And I am deeply sorry that you've been subjected to such a violation as this, you and your children. But I do appreciate you being here today and bringing light to this situation and making it real.
Yeah.
Making it real.
I know. And before they were saying, you know, well, we've got our child. We were conceived, or I conceived and was able to have children, but not by the doctor, you know, whose trust you have.
Right.
You know, that he's in the other room having a good time for himself and then inseminating us, and we don't know this.
Yeah. Atrocity.
And
And
plus
I
he's
truly
been-
am sorry.
Right, doing it over a number of years in the same area, so that there's a lot of us that are intermingling, which is
Absolutely. And that's really scary. So
right.
Thank you
Right.
again for being here today and bringing light to this in a very real and tangible way.
Thank you.
You're welcome. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, Ms. Hill, thank you very much for joining us this afternoon. Sorry
Thank you.
you had to join us for this reason.
Yeah.
Steve Arante?
Good afternoon, representatives. I'm Stephen Arante. I'm a lawyer in New Haven with the firm of Lynch, Trout, Keefe and Arante. And as far as I know, we have the only pending case against Dr. Caldwell, and that's why I'm here. As you may have gathered from the prior testimony, he's a serial inseminator with at least 23 half siblings out there that they know about. Looking at the statute, there are a couple things that I wanted to bring to the committee's attention. One was brought up earlier by Representative Fishbein, that there's a question here about statute of limitations. The case is pending. The issue that's been raised is that it should be 2 or 3 years from the act. And of course, we've argued, although it hasn't been decided yet, that it really should be 2 or 3 years from when you find out. And in most of these cases, virtually all these cases, no one finds out until the children participate in 23andMe or Ancestry.com and find out. And the bill only makes doctors responsible, but the bill really should be broader than that. To anyone who facilitates this from happening, if they knew the doctor was doing this, they should also be responsible, or the institution that they are working for, if the institution has not supervised them properly. In addition, and part of the defense in the case is what Representative Fishbein mentioned, was that, well, you sort of got what you wanted, you have your child. But first of all, it's no longer anonymous. It's only anonymous as a one-way street here. The doctor clearly knows. And so the anonymity is really gone. In Dr. Caldwell's case, he was very interested in how far these people, the victims, went to school and what sports they participated, almost like it was a science project. And a corollary problem that's not part of this bill at all is really the number of donations. It's particularly heinous when it's the doctor who's violating the trust of the patient. But it really is broader. Any male who donates so many times is going to create the problems that you just heard about from the prior speaker, of having half siblings out there, possibly having sex with a half sibling, not knowing, having siblings that you're in school with. That is also a major problem that's not taken up by this bill. So if this bill were to be passed, I think a couple of things that would have to be changed would be making it clear what the statute of limitations is, and broadening it to include people other than just doctors who participate in this fraud on the victims, the women who come to be inseminated. Thank you very much.
Thank you. Comment or question from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. I must share, I have some difficulty with two people contract. There is performance of the contract resulting in a child and a third party having the right to bring a civil legal action. Because under what you were just talking about, that is the offspring, right? That's the result of the contract bringing the civil action.
Yeah.
How do we, policy wise, when we were not a contracting party, how do we deal with that? That would be totally unique in the way we do things.
Well, I think it would be akin to a third-party beneficiary. Clearly, the goal here is to produce a child, so it is not beyond the realm of possibility. In fact, it's the very thing that the doctor was trying to accomplish here, to produce a child. And so it should be no surprise to the doctor that that child is going to suffer the consequences of his violation of that contract, because the contract was for an anonymous donor, not for the doctor to be a donor. And so there's a breach of that contract, and there's a third-party beneficiary here who's been injured by that breach. And so I don't think that is all that unique to our system. I think it's very foreseeable that the child is going to be the one who suffers the most from what happens here, even though it is going to be 20 or 30 years later when the child finds out.
But how do we ascertain a cognizable injury? For instance, you were talking about the I don't even know what the medical term is for it, but somebody being a multiple donor and the contracting parties, you know, there's the insemination, child is resulting, and the child that results has some sort of allergy, let's just say. How is the doctor, let's just say, you know, statute of limitations allows for, let's say, 25 years, right? So you know, age of majority plus a window of 7 to bring the action. How is the doctor ever going to defend that case of improper or not liquidated, but not a donation that is of such value and virility than others? I'm just trying to, this is a civil action, right?
No, I understand your question. And I think you limited it sort of to the physical manifestations that might take place if the doctor has some genetic, you know, predisposition for some disease that would be passed along to the siblings. But I think you're overlooking the part of the psychological part to these children once they find out, and lawyers and the parties would be left to their proof to convince a jury that these are their damages, worries about diseases that they may have, emotional discord because they may have gone to school or had sex with a half sibling. The fact that every time they go on to ancestry.com, there's a bing and suddenly they have a new half sibling, and their children are going to have, you know, multiply that by I don't know how many cousins. Those are all things that a jury is there to determine really how much effect it had. On some people, it might have very little effect, in which case there might not be that much in damages. On other people, it may have a catastrophic effect, and for which they'll have to convince a jury that it was reasonable to have that damage sustained as a result of what this doctor did in a fraudulent way. Juries do that all the time.
So shift the public policy situation to adoption. And many people who are adopted don't know if they have siblings out there, who their biological parents were. If we fundamentally say that lack of knowledge, at least in the present, is actionable in the future, isn't it similar to the adoption situation?
No. It's similar in some ways, but it's really different. First of all, when you're adopting, you know that's what you're getting. Here,
but this is the child, though. This is the action brought by the child.
Correct.
So you've taken it away from the contracting parties and you're extending it to the offspring. So now you have the adopted child who doesn't know whether they have offspring, whether they have siblings, don't know who their biological parents. It is the same basic situation. They are similarly situated.
I don't think they're similarly situated, because in this case, what the goal is to use incentives to prevent the doctor from doing what happened in Dr. Caldwell's case. And this statute is aimed at preventing doctors and medical people or quasi-medical people from inseminating people in a fraudulent way, which is entirely different than the medical problems that you're talking about that might result from an adoption, in which the parties understand that that's what they're getting into. And I understand your argument about, well, the child, but in this case, the child is not, in the adopted case, the child is coming from a parent from somewhere, whether it's the United States or outside the United States. Here, you have a doctor who is inseminating a number of people, and we know several other cases. In fact, we're looking into another case of a doctor here in Connecticut who did the same thing, maybe not quite as much as Dr. Caldwell. And that is going to be a proliferation again of more and more siblings, half siblings, and cousins, which is different from the adoption situation, which is very limited to just whoever the parents happen to be, and the odds of this intermingling of people. And there is no fraud or ill will there, where there is a fraud and ill will here when a doctor is intentionally doing that, intentionally hiding it, and intentionally deceiving, is very patient. So they're really different situations in my mind.
They are, but once again, we're dealing with a civil law. We aren't dealing with a criminal law. When you say we are looking to pass this law to prevent this from occurring, that is actually not true, with all due respect. Because as long as somebody can pay damages, they will continue to do it, right? If they go to jail because it's a criminal thing, they don't have the ability to do that. So if you really want to stop the action, then you make sure it's criminally prosecuted, which, I mean, you're a lawyer. Can you tell me, since you're involved in at least this case, is this a crime?
It would be a crime, except it usually is not discovered until after the statute of limitations is expired. And we have many things where it is a crime, and also there's a civil obligation. And since in most of these cases, because 20 or 30 years is going to go by before it is found out what the doctor did, the criminal statute, the statute's gone, and the only remedy is going to be civil. And nothing is perfect, but if I'm a doctor and I know that I'm going to be civilly obligated if I get found out, that is at least some disincentive for them to continually impregnate people with their own sperm.
No, I got it. And maybe, well, I'm still more in the criminal sphere than the civil sphere.
I certainly have no problem with it being a crime and extending the statute of limitations as a crime also, but that's not what we're here to discuss today.
Well, we are here to discuss the language before us and any proposed changes as a professional that you would have us consider, because that's why we have public hearings, right? So I enjoy the discussion, and thank you, Mr. Chairman.
As do I.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon. Next, we'll hear from Xavier Valadon.
Yes, can everyone hear me?
We can hear you.
You can hear me? Okay, perfect. Good afternoon, Chairs Winfield and Statstrom, and members of the Judiciary Committee. Thank you for the opportunity today. My name is Sabian. I'm a resident of New Haven, a member of Yale College Democrats, and I'm here.
Mr. Valadon, you're breaking up on us, and it's very difficult to understand what you're saying. Can you try turning off your camera?
Breaking up? Okay. Yes. Let me try this. Is that all right?
That seems to be much better.
Better? Okay, perfect. I guess I'll just go where I left off. So it should go without saying that intimate partner homicide, for example, is a devastating situation for a child and their relatives. I've worked very closely with children throughout my life as a teacher, tutor, counselor, babysitter, and as a mentor. Though fortunately, none of them have been afflicted with such an event, I find it almost unimaginable how much of a burden it would be for them to go through something like this. If they were to undergo such a disaster, I know that I would want SB 359 in place. Research shows that a child whose parent is killed through intimate partner violence is prone to negative mental health outcomes. A 2015 study identified 4 distinct negative outcomes of this: psychological, social, physical, and academic regressions. Negative social outcomes are almost entirely associated with attachment difficulties to children's new caregivers. This can happen due to hesitancy accepting a new caregiver or unwillingness to form new relationships before reconciling with the death of a loved one. That reconciliation is made even more difficult by the fact that in many cases, these children are losing the very person they need, their mom or dad, to get through difficult situations. The transition to a new caregiver is not an easy one, and is not made any better if there's constant unease about who might be able to care for the child and if they understand the process for doing so. While this bill can't reverse the death of a loved one, what it can do is relieve that extra burden and streamline the process for delivering care to the child. We also know that there's a very real burden placed on the relatives of the child following an intimate partner homicide. They might feel conflicted on whether they have the resources to care for the child or feel intimidated by the process of finding care for or potentially fostering the child. Most people don't predict or anticipate intimate partner homicide, for example, so that means most people have little to no exposure to these processes. While there are public resources available to help aid in the process, discovering them is a process in and of itself. These public resources are meaningless if people don't know about them, and this bill creates a more direct link between children, relatives, and caregivers to these resources. A New Jersey statute requires a public outreach campaign to promote education on the availability of resources to address domestic violence. Though New Jersey statute is tailored to domestic violence, it recognizes the importance of educating the public on vital resources addressing urgent needs. Let's start this type of work in Connecticut with SB 359, and thank you.
Thank you very much. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon. Next, we have Allison Becci. Hope I didn't get that too far off.
It's VC.
VC. I was going back and forth. You took a guess.
It's okay. Okay. Good afternoon. My name is Allison VC. My mother, twin brother, and I are all victims of fertility fraud. My twin brother and I took a DNA test in 2022, and our hearts dropped when we saw my mom's fertility doctor's last name on our chart. We can't begin to tell you how emotionally and traumatizing this has been. Not only was he my mother's fertility specialist and her lifelong gynecologist, he was also my gynecologist as a teen. I would have never consented for him to examine me or do a cervical screening if I knew he was my biological father. It's beyond violating. There was no consent from my mother for him to be the donor and give his own sperm. Furthermore, my mom and I went back to him when my twin and I started to have medical conditions. He lied, said the sperm bank burned down and all medical records were destroyed. He also went on to say, "Don't worry though, you probably have good genes and it is likely a medical student donor." Now, upon speaking to some of his biological social children, we've since learned most of our medical conditions came from his side of the family. Some of his children called us liars and questioned our integrity, even though actual DNA and science linked us. What this doctor did to us was completely incomprehensible and unethical. He made a medical oath to protect his patients, but instead lied and used his power of authority to do what he wanted. He ruined our faith in the medical system. We have since found out that we have 13 half siblings and 40 plus nieces and nephews that we will never probably get to know. We have a high inclination there are possibly more. Our doctor's case happened in the state of Nevada, but thankfully last summer, Nevada passed their fertility fraud bill. It's been 2 years of fighting, but our case will be public and will be filed in court within the next couple weeks. We are hopeful to seek some sort of justice and peace with the filing. My mother and I do reside in Connecticut and are here today to ask to please support Fertility Fraud Bill 5423 to help people like us. Let's hold doctors like ours accountable for their unspeakable actions and crimes. And just one more thing, I do want to add that since most people aren't finding out this act of deceit until decades after the fact, please don't place any stipulations or limitations on the number of years from the act it was done.
Thank you.
You're welcome.
Comment or question from members of the committee? Comment or question from members of the committee? Representative each.
I'd just like to make a comment and thank you for coming out and sharing this horrible, horrible story with us. I'm certainly sorry for your problems. Very
Thank you.
sorry. Thank you.
Thank you, Representative. Comment or question, Representative Porter, do you still?
Yes, thank you, Mr. Chair, and same here, no comments. Same comments I really made to your mom.
Oh, that was Victoria's mom. My mom is here though to support as well.
I'm sorry.
Thank you.
I can't imagine. The more I sit here and listen to this, the more disturbed I get. I mean, like, it's really a bellyache.
And a lot of doctors, you know, the more doctors are coming out of doing this, so I don't know what they were thinking, but there has to be some kind of crime against what they did.
Well, you would think it's a crime. I mean, I
Yeah.
would think it's a crime. And the one thing that I will say is that I absolutely support this bill.
Thank you.
I support no statute of limitations.
Thank you.
It makes sense. And I definitely support that it should include any and everyone, right? It shouldn't just be limited to doctors, but doctors specifically, because they are the ones that have access and are right doing this. And it really is a breach of their oath, of character, of morals, of principles, of values. I mean, you name it. It's an extreme violation.
Yeah.
And I just really, I feel for you and everyone that's been impacted by this doctor and other doctors that are now being discovered to be doing this. But I want you to know what's being said here today is not falling on deaf ears.
Thank you.
And that
I really appreciate it.
you have my support. Thank you, Mr. Chair.
Thank you, Representative. Comment, question from members of the committee, comment or question. If not, thank you very much for joining us this afternoon.
Thank you. Thank you so much.
Janine Pearson.
Good afternoon. My name is Janine Pearson. I'm a resident of Canton, Connecticut, and I'm here today in support of House Bill 5423. In July of 2022, I took a 23andMe DNA test and learned that I am the product of fertility fraud. I learned the shocking truth that my biological father is Burton Caldwell, the very fertility doctor who performed artificial insemination on my mother in 1986. At the time, he told my mother he would be using an anonymous Yale medical intern's sperm for the procedure, but instead he used his own without her consent. When I shared the truth with my mother, she was absolutely shocked and horrified. She felt violated, deceived, humiliated, and traumatized. She trusted this doctor to perform a very personal medical procedure with transparency and professionalism. And when she left his office unaware of what happened to her own body, she was also unaware that she would carry and raise her own doctor's child. Not only did we learn that this doctor was my biological father, but I have also matched with 23 half-siblings to date through multiple DNA websites. I have siblings who have dated. I have grown up in close contact with other siblings, all while completely unaware of any of this. Learning that I am the product of fertility fraud has impacted my entire identity, as well as my mental health. I'm in constant fear that anyone I know could be my half-sibling, and it has forever changed how I feel about placing trust in medical providers. So I ask you today to please pass House Bill 5423 to protect other families from what we have and continue to endure. I would also recommend that the statute of limitations to take action and file suit either be increased or erased altogether. Many of my half-siblings had no idea when they first discovered the truth that there would be so many of us and how deeply traumatizing this experience would be as time goes by. But by the time they effectively process the information, they have been unable to seek justice due to the 2-year statute. I would also suggest creating a minimum amount for damages to make victims whole, as the impact of this for the future is completely unknown. At any time, we could find out we dated a sibling, a close friend, or a relative. We also do not have access to important medical history to accurately screen for and assess health risks. I'm currently 9 months pregnant, and once my son is born, he will have 42 first cousins that we are currently aware of, many of whom live in close proximity to us. The likelihood that he will date or mix with his cousins one day is terrifying, and it illustrates how this deceit and intentional infliction of non-consent has consequences which trickle down through multiple generations. In closing, we ask you to please pass House Bill 5423 to prevent this from impacting other families, to protect the people of Connecticut, and to allow victims and families to seek justice. Thank you.
Thank you. Comment or question from members of the committee? Comment or question, Representative Porter?
Thank you, Mr. Chair. And same sentiments, I'm not going to belabor what I said. It goes for you as well. The one thing that I do want to do is congratulate you today on that little being you're carrying in your belly. That's a big deal. So concentrate on that. Be happy for the blessing. I'm going to keep all of you in my prayers. Thank you, Mr. Chair.
Thank you, Representative. Comment or question? Comment or question? Seeing none, thank you for joining us this afternoon.
Thank you.
Patience Crozier.
Good afternoon. I am Patience or Polly Crozier. My pronouns are she, her, and I'm the Director of Family Advocacy at GLBTQ Legal Advocates and Defenders. Since our founding over 40 years ago, protecting children and families has been at the core of our work, and we work really closely with partners in the reproductive rights movement, and that work has deepened in the shadow of Dobbs. We have seen, after the Dobbs case, the rapid acceleration of attacks on reproductive rights and on the basic right of people to make the most private decisions about themselves and their children. 23 states have passed ban on essential medical care for transgender people. The Alabama Supreme Court issued a truly fantastical opinion in February that essentially shut down family building healthcare in that state within a week. And unfortunately, the legislature's fix was not a fix and harmed patients even more by removing malpractice claims for all reproductive healthcare retroactively. We saw last week that the West Virginia Senate passed legislation to partially criminalize surrogacy, and Kansas moving legislation to prohibit embryo disposition. So in short, what we're seeing really is a broadening attack on reproductive rights in many ways, which is really concerning for people who rely on fertility healthcare like assisted reproduction and gamete donation to build their families. So I'm here to testify in opposition to the Fertility Fraud Act. I obviously want to say it goes without saying that the people, many of whom you've heard from today, whose doctors betrayed their trust so terribly by using their own sperm rather than the donor sperm as they were promised, and the people born from those misdeeds have suffered tremendous harm and trauma. I really appreciate the efforts of the Judiciary Committee to raise a bill that's narrow, but I wanted to share that we do oppose fertility fraud legislation. We think, of course, there should be accountability for doctors who commit grievous misconduct, but we hope that first we can explore existing accountability measures under tort law, under medical licensing provisions, and urge policymakers to be cautious to avoid unintended consequences in addressing these issues. And that's because not the folks here with you today, in the fertility fraud movement seek to end assisted reproduction and gamete donation. The pending federal legislation that is championed by Representative Bice and might have a companion bill filed soon by Senator Katie Britt has language that's so broad it could effectively leave parents open to lawsuits from their own children for using an unknown sperm donor. So those provisions and in some and other states are part of a broader effort pushed by some to turn back the clock on all people, including ending no-fault divorce, ending same-sex marriage, ending assisted reproduction and surrogacy, and opposing efforts to expand access to fertility health care, which for so many people is necessary and so wanted. So we just want this committee to be cautious and ask the question about what existing mechanisms are there to address these terrible actors, and how the legislature can address the harms without unintended consequences.
Thank you. I'm going to ask you to help me understand your argument. I understand your argument about some of the other bills as it relates to the more narrow bill. Could you, in like a paragraph, explain exactly what the opposition is, so I'm not mixing up your opposition to some of the bills outside of the state and your opposition within the state?
Well, I would say, I think in my testimony, thank you so much, by the way, for that question, and happy birthday. I think it's a good question. I think one of my I mean, I've had a number of conversations with folks in Connecticut about this issue, right? Because I know there's some Connecticut families who are really suffering tremendously. And I don't think those questions have been answered yet. And the questions are, what happened? Like, what are the medical licensing boards doing to police doctors? What are the existing claims that people can pursue? Because, for example, in Massachusetts, where there's no fertility fraud statute, there are claims going forward for fertility fraud. So it is more of I see really, and I'm happy to share with the committee kind of some of the principles that the LGBTQ and reproductive rights movement have put out there around this issue, because I think one of the things that's important is just understanding what are some of the existing mechanisms that we have before we move to legislate in this area, because again, there are so many efforts out there to restrict access to fertility healthcare, to family building, and many of these bills become a vehicle to do more. And I just want to say to the committee, there is another person who's going to testify today, who's a law professor who works on this issue as well, Professor Krashel, who could likely be helpful in answering some of those questions as well.
Thank you. And I'll just say this, and
yeah,
one, it's good to see you again. Thank you for the happy birthday. The work that you do, I think is particularly important. I do have a concern, despite what you're saying about what some of the other bills do, about the very bill that's in front of us. So we have time before this bill, if it hits the floor. I would implore you and anyone who has concerns to make sure that we are clear what those concerns are, as we don't know whether the bill moves forward or not. And if it does, and you have concerns that are legitimate, I think we want to really address those. So I walk away from today not really clear about the concerns in this particular bill, except that it could link to some of the work that's being done in other places for different reasons. So I just want to make sure.
Well, yeah, sure. I mean, I will say, one person testified today talking about, expanding out to what seemed to be to addressing sperm donors in a broader way, right, as opposed to physicians. And I think, anyway, to the extent that there are amendments that are suggested or there's other things that are being considered, certainly GLAAD would want to be part of that conversation and work closely with the committee to avoid any unintended consequences. And I'm happy to, provide more details on that to the committee.
Thank you. And I would be very happy to receive any of that. I want to make sure we do this correctly. Representative Howard.
Thank you. Thank you for being here, ma'am. I sort of want to align my questioning with the chairman. You're not testifying from within Connecticut, is that right?
GLAAD works throughout New England and on LGBTQ issues. I personally am not in Connecticut, but we have worked in Connecticut for decades on various issues such as marriage equality, parentage equality, and a number of other issues.
Do you know about the Parentage Act that we passed here in 2021?
Yeah.
So, when you talk about fertility with the LGBTQ community, I mean, that's an important issue for me. I have several friends that are same-sex couples that have used that to create their families quite successfully. And you talk about reproductive rights. Now, I certainly don't want to cast a vote in favor of a bill that limits my friends specifically, as an example, from creating their families. I don't understand, and I'm asking for you to help me understand how in Section 1 that would affect their ability to do so, because as I read it, it's very narrow. It's one sentence, and it has the burden of knowingly. So as I read the bill, a physician would have to knowingly use his own sperm to inseminate a patient without their consent. I don't know how that breaches into the ability of couples to use fertility in the way that they intend to. If you could help me understand that.
Well, as my testimony reflected, some of the state fertility fraud bills go much, much farther than that. I've had a number of conversations with folks in Connecticut about kind of the scope of fertility fraud. I mean, I do think that this bill is pretty much, you know, as narrow as one can go, which I think is very positive. Some of the other state statutes are really broad. Some of the statutes require, you know, seek to, and some of the bills that are out there seek to have a registry, for example, of everyone who's.
Ms. Crozier, just briefly, we're on the bill before us in this committee.
Mhm.
And so I think I understand your argument about, and certainly, you know, at least personally, I share your concern about what folks have done in other states, particularly in some southern states, some red states, et cetera. But we are here in, you know, bright blue Connecticut, on this Judiciary Committee, and I think what we're looking for is there a legitimate concern with the language of the bill that is presently before this committee? Because if there is, you know, I for one would certainly be concerned with that, and it sounds like so would my friends across the aisle.
Yeah.
But
So I'm happy to
talk about this bill.
Yeah. Well, I'm happy to, and I actually have to go to another hearing in another state, so I'm happy to be quick, which is to say, you know, I was surprised to see this bill filed in bright blue Connecticut, given what I know about the trajectory of these bills across the country. So I'm glad that this bill has been narrowed, but this bill is an issue that is being used in other states. So I am happy to meet with the committee to discuss this further at your convenience.
Further questions or comments from the committee? Further questions or comments? Seeing none, we'll let you get off to your other hearing.
Thank you.
Next up will be Crystal Rich. Is Crystal Rich with us? No. All right, Steve Sedensky.
Good afternoon, Representative Safstrom. Good afternoon, Senator Winfield, and members of the committee. My name is Stephen Sedensky. I'm a Special Assistant State's Attorney and a retired State's Attorney for the Judicial District of Danbury. I continue to prosecute with the division child sexual abuse cases, and I am testifying in support of House Bill 5298, an act clarifying the meanings of sexual intercourse and sexual contact. That particular bill was drafted in specific response to two cases that came about in 2022 from our Supreme Court. One, State versus Douglas, and the other, which specifically applies to sexual assault cases, they came out at the same time, but Joseph was a specific situation in which the defendant was charged with sexual assault in the first degree on a minor, as well as risk of injury to a minor. The victim made the report when they were 13 years old. When they testified, part of their testimony included, I'm going to read from the case. The victim also testified beyond the incidents. He described many other incidents of sexual abuse involving the defendant and T, and blurred together. Many other incidents had blurred together because there were too many to count and distinguish between. These incidents, which always occurred at the victim's father's, involved the touching of intimate parts, oral sex, anal sex. The victim recalled the defendant and T abused him simultaneously and would frequently take turns to trade off. The Connecticut Supreme Court, the majority opinion, determined that our specific language of sexual assault punishes specific acts and not continuing course of conduct. So the way the majority interpreted it is that the state would have to prove specific acts, even though repeated acts took place over a long period of time. Okay, and the court specifically noted the problem in child sexual abuse cases. And what they said was, we are sympathetic to the plight of both the young victims, often unable to state except in the most general terms when the acts were committed, and of prosecutors either hampered by the lack of specific information or when it was reported that the conduct occurred dozens or hundreds of times. But then they go on to say, sympathies aside, however, we only have the words of our sexual assault statute to interpret and to apply to the federal case. So it is with that this this legislation or this act, House bill, addresses to correct that specific situation, to allow prosecutions for continuous course of conduct, which existed prior to the Joseph case.
Attorney Studenski, let me ask you, have you had a chance to review the public defender's testimony on this?
I did. As a matter of fact, I have comments on that.
Okay, that was good, because that was what I was going to ask you, because this is, I think, now at least the second year we've had this bill before us. You know, and I'll admit, I have not studied, I think I read them last year, but I admit as of this year, I did not go back and reread the Douglas or the Joseph case for today. So their claim, as I best understand it, is this bill goes beyond sort of the four corners of those two cases and represents more of an expansion. And I'm just wondering what your response to that is, and whether there's been any effort by the state's attorney's office to sit down with the public defenders and see if we can work out a compromise on this.
My response is that it absolutely does not go beyond those cases. If one looks at the title of the statutes, it's to clarify the meanings of sexual intercourse and sexual conduct. And then if one looks at the statement of purpose, it's specifically to correct those two cases. I am not aware of any conversations that may have occurred between the public defender's office and the Division of Criminal Justice. Having knowledge of the cases and having done these cases repeatedly over 35 years, I know that it's a very, very specific issue that allows for prosecution of continuous course of conduct. With regard to specifically comments of the public defender in their testimony, I have read it. It will not change the burden of proof. Prior to State versus Douglas and Joseph, the burden of proof was and remains that state has to prove the case beyond a reasonable doubt. Okay. I mentioned it does not go beyond the cited. It does not go beyond the cited cases. And they mentioned, oh, this will be taken care of with a bill of particulars or a unanimity charge. Well, no, it doesn't take care of the problem, because the bill of particulars and the unanimity charge will specifically require the jury to find the child victim, to find beyond a reasonable doubt a specific act. So you could have a child that was repeatedly sexually assaulted over many, many years, and because they can't point to a specific incident, okay, in other words, describe a specific incident when that perpetrator was doing the same two things to them over and over, that bill of particulars will not cure that. We still have to prove that case beyond a reasonable doubt, okay, in terms of the specific act. So essentially what you're doing is you're saying, hey, Mr. Perpetrator, you know, as long as you continue your course of conduct for multiple periods of time with the same type of conduct so that the child cannot identify a particular conduct, then you're going to get off on that sexual assault charge.
Representative Callahan.
Thank you, Mr. Chairman, and good to see you, Mr. Studenski. I'm sorry I am not seeing you in person, my friend. Your testimony today, actually, to me, was very helpful in helping me understand the legislation before us. So I just wanted to let you know that your trip to Hartford was actually quite helpful.
Senator Kissel.
Thank you, Chairman Staffstrom. I have a follow-up question along the lines of what the good chairman elucidated. I have You said that you can't say what discussions were had with Public Defender's Office. Quite often, the leadership of this committee will lock you guys in a room together to see if you can reach a compromise. And maybe in your opinion, what I'm hearing is that this solves the problem, although let me take a step back. I don't take comfort if the title says one thing or if the preamble says something. I sort of get into the meat of what the specific item is in the bill proposal. And what I'm gathering from what you testified is that this solves the Supreme Court decision's issues. And it's heart-wrenching to me because like, I don't remember what I did 3 days ago. And if you want me to recount date and time, I'd have a hard time with that. If I was abused child and you wanted me to say, oh, it was this day at this time, it's never going to happen. I mean, everything in your nervous system and your body is telling you, I want to clear this from my memory totally. The anxiety and the trauma is so great. And now we want them to meet these criteria. You're not going to be able to solve your case or prove your case. So it would give me an assurance if you could just circle back with the leadership, maybe the chief state's attorney or somebody. What discussions have had in the last year or so to bring you two guys together? Even if they said no, even if the public defender said no, at least there was that reaching out. That would give me a comfort level. And is it your testimony, nice and clear today, that absent this bill as drawn with this language, which in your opinion is as narrowly drawn as possible and doesn't change the burden of proof, but absent this, we will continue not to be able to see successful prosecutions of these villainous individuals committing these horrendous crimes?
If you want to talk about the sexual assault charges, okay, because oftentimes there's a risk of injury charge that, depending on the circumstances, often goes with it, okay? Our Supreme Court did not interpret the risk of injury because of the language the same way as it interpreted our sexual assault statutes. So if we're looking at the ability to successfully prosecute sexual assault crimes, okay, not having this very, very limited change, which goes back to prior to pre-Joseph, okay, you're not going to get those unless you can find that 8, 9, and 10-year-old that can identify a specific instance. And sometimes they can. There may have been a quirk in what was ever done in a particular instance that they can recall that particular instance. But when you have similar conduct going on over a long period of time, very often, and I would say in most, if not in many cases, they're not going to be able to point to a specific time. It would be just as if you go to go for a cup of coffee every single day. And I don't want to minimize that and compare it to sexual assault, but you do something every single day, and then you're asked to remember about a particular day that you went coffee. There's no reasonable doubt that you went for coffee during this time period, but because you can't point to a particular day, you're not allowed to prosecute it.
Long response for a yes. And so I'm gathering that the response is yes. And risk of injury, hey, I could be driving recklessly and have a minor in the back seat and be charged with reckless and risk of injury. And so to me, that doesn't hit the nail on the head. And we need to have an effective statute in place on these matters. So if you could just circle back with the leadership in the state's attorney's office, just to send me an email or something like that, send the committee members that at least the offer was made to try to reach a happy medium. But if not, I still want to know that.
Yes.
Because what I'm hearing loud and clear is absent this fix, essentially, that based upon the Supreme Court's well-reasoned decision that the plain language will not allow these prosecutions to go to successful completion. Thank you, Chairman Stafford.
Further questions or comments? Representative Fishbein?
Thank you, Mr. Chairman. Thank you, Attorney Sadecki, for coming here today. I think it's been 3 years we've had this bill on our menu, and I think this is the first year that you've been here to talk about it. So I do appreciate that. I think my colleagues have outlined some of my general concern, because certainly I want any perpetrator of, especially upon children, to be convicted if they committed the crime. But the problem that I've wrestled with this language is the individual who is defending those allegations. So, if we meld all this stuff together and, once again, I'm glad that you're here, but why not? You could have one charge that you could probably prove based upon DNA and all of that stuff. Please refute. I mean, the problem that I'm having is this continuing course of conduct that is unpinnable shifts. So if a child says John Smith did these bad things to me and it meets the test and you have DNA in inappropriate places, why do we need this?
Boy, if we had DNA in inappropriate places in these cases, we wouldn't be here on that. These are not cases where there's DNA, okay? I just finished a case where the report of the sexual, in Waterbury, where the report of the sexual assault took place years after the sexual assault. And the abuse that was occurring was not something that would leave physical injury. So in the vast majority of the cases, especially with children, okay, you're not going to have any DNA. You're not going to have physical injury. One of the things that I've just learned over the years is that this type of abuse doesn't leave a physical mark on the child in the vast majority of cases, okay? So that you're not going to have that. And prior to this case, what we would see in prosecuting these cases is that we would charge a time frame. Okay, and oftentimes we could locate, say, a location, whether it was at the victim's house, whether it was at the offender's house. And what we would do is we would have one count, and then the child would testify with regard to what had occurred in the house, okay, but not be able to identify a particular incident because the abuse was so consistent as what the offender chose to do. So it's not really a question of DNA. Boy, I'd love to have cases with DNA. We just don't see that in our cases.
Well, I'll tell you, I have one right now. So, and DNA is
pretty good case for the state.
Well, for some reason, it's been a year and a half, and the implements that are supposed to be tested have not made it through the lab yet. So it's been quite a long time. All right, well, I appreciate the conversation. I do share my colleagues' concerns.
May I just add one other thing?
Absolutely.
Okay, I would just note that in the dissent, and this just really shows why it needs to be clarified in the dissent. I believe it was Justice Mullins indicated that he did feel that the language of sexual assault did include a continuous course of conduct. Okay, he wasn't in the majority, but it just shows that this was not an opinion of all the justices, and that's why a clarification needs to be had.
Well, this language, though, melds the two together, right? It says a single act or multiple acts that occur over a period of time as a continuous course of conduct. So they are, if this language as presents was to pass, they would be melded together as one.
It would go back to the prior Joseph or Douglas practice as to what we were doing. It specifically just corrects those two cases.
So what if we bifurcate the two? Would that, if we have that a single act is a particular crime and a continuous period of act is a different higher crime, what if, would that solve the problem?
No, because you're still not going to be able to charge the sexual assault unless you can point to a specific act. So now what we would, let's just say you pass the statute or you pass the bill, okay? And we have a specific act that we can prove. Let's just say that there was something, it was in a different location. It was still during a particular time period, but it's at a different location so that the child can identify that particular act. we could charge that one separately. If the bill passes, we could then also charge the time period for the other continuous act. Okay, so the way I've done it over the years, excuse me, is to say, you know, you have the one that you can certainly say specific act, but then the other one just falls under one count of a continuous time period.
So you would agree with me that illegal sexual conduct with a child is going to have some level of negative psychological effect upon the child.
That's been,
Yeah,
yes, I
right,
would
you
agree
agree
with
with
that, yes.
And that a period of that bad act is more than likely going to have a more severe negative impact upon the child.
Yes, because in those situations, the person is generally someone who is close to the child or has a lot of connection, access to the child.
Yeah, so it's a breach of that trust, right? But putting them together, do we still have the ability to deal with them separately? Is there a different crime? So I'm looking at it that one, the continuous course of conduct that is bad is more harmful to the victim, both harmful to the victim, right? And that's where I'm having a problem with putting the two together, because then you can't charge for that additional harm to the victim.
I disagree, because you can separate the individual act that you can prove with one count, and then the ones that are a continuous course of conduct, you can have that as another count, okay? And depending on the situation, you could break that up into multiple counts. It really depends on the type of information that the child can provide. And what we do rely on is the sentencing scheme of the judge being able to look, let's just say they're found guilty of the continuous course of conduct. The judge can then take that into consideration in imposing the appropriate sentence, knowing that it was a continuing course of conduct.
Thank you, Mr. Chairman.
Other questions or comments? Just real briefly, just to sort of hopefully bring this to a close, Attorney Stensky. So I think what I'm hearing is there very well may be, and frankly probably is, a need for some clarification here after these Supreme Court decisions. I guess my concern as I sit here is I take seriously the charge from the public defenders that the language as currently written is not clear enough to make clear that we are not shifting the burden of proof and that we're not going to run afoul of a Sixth Amendment problem. But those seem like hurdles that we should be able to get over those. You know, I think this is the second or third year this has been around. I guess I would just implore you, so that we hopefully can move this forward this year. I mean, the public defender's office, they're here. They're in the back of the room. If you guys want to go in my conference room, feel free. You know, you got the rest of the afternoon, and go hammer this thing out, because I mean, it seems like a drafting issue at this point.
I really have to disagree with their written testimony, because it really, other than saying it doesn't really fit those cases, they don't address the specific language of State versus Joseph, where they specifically say our legislature may wish to consider similar legislation. I mean, they just say it doesn't, our bill goes beyond that. They say that, but then they really don't address, as we did, the specific language of Joseph.
All right, I hear.
I will speak.
I hear what you're
Attorney
saying.
Sullivan.
I'm telling you now, if you'd like this bill to move out of this committee, you need to go talk to Attorney Sullivan on this.
I will certainly do that.
Thank you.
Okay.
All right. That's it. All right. Next will be Catherine Krashel.
Hello, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Catherine Krashel. I'm a professor of law at Northeastern University. where my research focuses on fertility care and assisted reproduction. I live in Mystic with my wife and our son. While I am deeply sympathetic to stories told today, I'm submitting testimony in opposition to House Bill 5423, an act concerning fertility fraud. The proposed legislation is an unnecessary and problematically exceptionalizes reproductive health care in a moment when reproductive health care is under attack. There are two main reasons why this legislation is unnecessary. First, the field has changed over the past 40 years such that the opportunity for fertility fraud to occur is extremely limited. And second, that multiple areas of existing Connecticut law, including physician licensing and consumer protection and anti-fraud laws, can address incidents that could occur. As many of the difficult and poignant stories of instances of fertility fraud illustrate, in the early years of fertility care, it was not uncommon for patients to consent to the use of fresh sperm samples from a medical resident or physician on site. These conditions provided ample opportunity for physicians to substitute their own sample without their patient's knowledge. These practices, even the use of a resident physician's semen with the patient's full informed consent, are outrageous under today's standards. Standards of professional ethics, patient care, and laboratory practices today make it extremely difficult for a physician to use their own sperm. And the cavalier and informal practices that harmed patients so deeply are not tolerated in the field today. In addition to changing norms of the field, thankfully, multiple layers of legal and regulatory safeguards exist today. First, the FDA requires clinics or sperm banks who use donor sperm to screen for infectious diseases and quarantine samples for a period of 6 months to screen for conditions such as HIV. Using sperm from, quote, the resident who most resembles a patient's spouse is not only no longer standard practice, but runs afoul of federal law. Second, federal law requires HHS to set up certification processes for reproductive labs under the Fertility Clinic Success Rate and Certification Act of 1992. HHS established certification standards in collaboration with the College of American Pathologists, or CAP. It is my understanding that every reproductive lab in the state is CAP certified. Among other things, CAP certification has specific requirements regarding sample identification and requiring specimen identification at the point of collection and time of insemination, and that identification has to be recorded. Simply put, legislating today, sadly, will not address the harms of the past, and HB 5423 does not address a pressing contemporary problem. We should not target the whole field to address a few bad actors. Next, existing Connecticut law addresses fertility.
Ma'am, your time's expired, and I believe there are some questions for you. So let me just ask about. I think your last comment there kind of caught me, which was legislating the entire field to correct. I think you said a few bad actors, but the bill before us, right? You probably heard the colloquy with one of the previous speakers, but I'm not worried about what's going on. I mean, I am worried, don't get me wrong, but for today's discussion, I'm not interested in what's happening in Tennessee and South Carolina and frankly places I would never in a million years live. But what I am concerned about is in Connecticut, and the bill before us, which I think is fairly narrowly crafted to deal with a situation that has occurred with at least one, if not multiple doctors in the state of Connecticut. And so what is the specific objection to that language that is before us today?
That it's not needed, and that the legislature ought not legislate in order to address issues that sadly happened in the past, and that there's existing Connecticut law that can address this issue, specifically the anti-fraud statute and consumer protection statutes. Section 421110B of Connecticut law states that no person shall engage in unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce.
That's a CUPPA violation.
And that
CUPPA violations do not apply to professional services. They do not. CUPPA violation cannot be brought against a doctor, lawyer, accountant, etc. So that doesn't apply. Try again.
Well, so there are, well, those claims, similar claims are going forward under an anti-fraud statutes are going forward in a case in the federal district court in Massachusetts. That there are ways, or I'm not a plaintiff's attorney.
Massachusetts may have a
but
different consumer protection statute than we do in Connecticut, but at least here in Connecticut, my understanding is somebody who's practiced commercial litigation for the better part of 2 decades and has brought and defended countless CUTPA claims. It's black letter law in Connecticut that CUTPA does not apply in the context of professional services.
So I'm not certain of this, but I'm guessing that it probably wouldn't apply to conduct that would be considered outside of the scope of what they're professionally charged to do. So I would say that a doctor who was using their own sperm was acting outside of the scope of what they are supposed to do as a professional, that it wouldn't fall sort of within the purview of the usual way that we address professional misconduct, such as med mal claim or something similar. That in fact, I would argue that that exception wouldn't apply because they weren't acting by using their own sperm was an act that wasn't within the scope of what they're doing as a licensed medical professional. Conversely, we do have medical licensing laws that allow the state medical board to sanction and revoke the license of physicians if they were acting in a manner in this way. And that Connecticut law, the general statutes 2013C empowers the state to restrict, suspend, or revoke a license or limit the right of practice of a physician for illegal, incompetent, or negligent conduct in the practice of medicine. So they've got to be either acting within their practice or outside of it, so that these claims could be brought under other areas of Connecticut law.
License revocation doesn't provide restitution for a victim, though.
That's true. However, again, neither would the very difficult stories that we're hearing today also would not be restored by this legislation. And that's part of what I was talking about in the first portion of my testimony, that, sadly and unfortunately, 20, 30 years ago, the practice of fertility care was much more cavalier. Physician paternalism, especially in the context of reproductive health care, was more likely to happen. And these practices, while common then, are just outrageous and extreme outliers in the practice of fertility care today.
Appreciate your testimony. Brief question from Representative Howard.
Thank you, ma'am, for testifying. You live in a wonderful section of Connecticut, by the way. But
thank you.
Your point is, you said that we shouldn't punish an entire profession for the acts of a few, and I don't think you're going to find a legislator in this building that agrees with that sentiment any more than I do. However, I don't think that this bill, I don't think by telling a doctor they cannot knowingly use their own sperm to inseminate a patient without their consent punishes that field in any way. Can you elaborate how it does?
Sure. So, I just think that we ought not open the door to exceptionalize a particular field. So I think that in general, there are, again, I understand the desire to focus on Connecticut, but we can't pass laws in a vacuum, and that there is a broader national landscape that has that reproductive health care, including fertility care, is under attack. And that I think that people could look to Connecticut and to say, oh, look, here's a blue state that enacted a fertility fraud bill without sort of understanding what our law does, or appreciating the narrowness of our law to say that we've opened the door to specific regulation of this kind of care. As an example to follow in a much more expansive way. So I think as Polly Crozier from GLAD noted, that I think we just, need to pause and make sure that we truly understand sort of the unintended consequences, and sort of the expressive force of the law, and saying that we are willing to pass a law that's specific to one type of healthcare before moving forward.
So I would
If there are other avenues, sorry.
I would just say that none of the proponents of this bill have alluded anywhere near restricting the ability for individuals to engage in fertility, up to and including being inseminated by their own doctor, if that's what they want, as long as they consent to it. This bill doesn't even preclude that. So, as you maybe have heard me say earlier, I have several friends that live down where you and I live that started beautiful families, same-sex couples who started beautiful families through fertility. I would never take a step here to interrupt their or anybody's ability to start the family as they wish. Even in your answer, I don't see how this infringes upon that, beyond the idea that because we in Connecticut said that doctors can't inseminate people with their own sperm without that individual's consent, that somehow that'll be construed in other states to restrict fertility. And I would say to you this: I live down in Stonington, over on the east side of town, the slightly better side of town, but I'm only joking about that. But I would be more than welcome, or more than willing, to sit and meet with you offline and to try to understand the concern, because I'm being very, very serious that I do not want to breach anybody's ability in this state to engage in fertility practices with consent with their doctor. So I'll leave that open if you want to email my office and we can set that up.
Thank you, Representative
Thank you, Rep. Howard.
Further questions or
And
comments?
I will say, I will just say, if I may, that I would echo what Polly Crozier said, that first of all, Representative Howard, I'd be happy to speak with you, yes. And also just echo what Polly Crozier said, which is that I am thankful for the committee and the drafting, as the bill is currently written, that unlike a lot of other proposed fertility fraud bills, it is very specific to a particular act that, as written now, doesn't do things like implicate more broadly donors or other people involved in providing fertility care. But I'm very happy to continue the discussion, and thank you for hearing my testimony today.
Thank you, ma'am.
Thank you.
Next up will be Victoria Hill.
Good afternoon, Mr. Chair, members of the committee. Try to not stop shaking. My name is Victoria Hill, and I am in support of House Bill 5423. I'm 39 years old and live in Wethersfield, Connecticut. I am the product of fertility fraud. I discovered that I was donor conceived when I was 35 years old through commercial DNA testing. My mother, Marilee Hill, spoke earlier. I'm sure you know the story by now. Her fertility doctor is my biological father, and I have many, many siblings. After learning this information, I confronted Dr. Caldwell, who very readily admitted to donating for many years and showed no remorse or concern. Every year, my family grows larger as more siblings test. There is even a Connecticut legislator that is in our pod. This is the gift that keeps giving, as now my children have 41 first cousins that I know of and are just in our close surrounding area, with more to come. In addition to this, in May 2023, after our high school reunion, I was talking with friends and learned that my high school boyfriend is actually my half brother, and his twin, also a very close friend of mine. I was intimate with this person and very much could have seen myself marrying this man and having children had we not gone to different colleges. I recently did a CNN article, and since it's come out, more victims have been reaching out for support and direction on where to go, many of which have been turned away by lawyers due to a lack of legislation. There are over 80 known doctors to have done this, and the most per state right here in Connecticut. There are at least 5 Connecticut doctors known to have switched out chosen donor sperm for their own. I am thrilled to see this bill introduced. However, we still have a long way to go. There are 13 other states with fertility fraud legislation. The one that is closest to getting it right is the Illinois bill that was passed in 2023. This passed as a civil cause of action against illicit inseminations. Victims are entitled to compensatory and punitive damages in addition to attorney fees. Children are entitled to the health history of the person who committed the fraud. There's an income tax exemption for damages received, and there's a long statute of limitations. It is the first law that is retroactive. For the Connecticut legislation, I would recommend not including a statute of limitations, as it is not conducive to fertility fraud due to the unique nature. Fertility fraud is unlike any other fraud. As I said before, it is the gift that keeps giving. This is important to note due to the time in which it takes to find out that this occurred in the first place, and then the ongoing trauma that presents as more siblings, cousins, connections, health information, and consequences are discovered. Many chirobanks right now are putting clauses into contracts that prohibit parents from completing commercial DNA tests and claim they are trying to keep donors anonymous. The problem that this causes is that the burden will ultimately fall on the child 18 years later, which then delays and/or blocks any kind of justice that currently exists in the system. Another concern that I have with this language is that it's not only a physician that needs to be held responsible, as there are other cases. One that just happened this past year where a lab tech switched out his own sperm 5 times. I believe this should apply to a physician, fertility clinic employee, or anyone that is involved in the assisted reproductive technology process that knowingly and intentionally switches out gametes. Which brings me to my last correction. I think we need to change the word from sperm to gametes, as gametes captures not just sperm, but other reproductive cells such as embryos and eggs, which have also been involved in fertility fraud cases that we know of. Thank you for listening and hopefully appreciating the importance of this legislation.
Thank you. And thank you in particular, not just for sharing your story, which I know was difficult, but also for providing very constructive feedback on the language before us and particular ways to address this and what other states have done. I greatly appreciate it. Senator Lester?
Thank you, Mr. Chairman, and thank you, Victoria, for having the strength to tell your story, but also, as the chairman mentioned, really thoughtful criticism about suggestions about how to address this issue in a way that allows people to get access to reproductive technologies, but allows victims to get compensation when they are wronged. And I think that that's the what we're trying to get right here. And you have an incredibly compelling personal story, and I'm just very sad about what happened to you and your family, and want to thank you for working to make the state a little bit of a better place.
Thank you.
Representative Fishman?
Thank you, Mr. Chairman. Thank you for coming here today. I'm sorry to hear about your situation. You mentioned a lab tech that had switched out sperm for his own. Can you just tell, I mean, the way I was facing this was, if a physician is hired to, perform on a contract and he needs a substance as part of the process, I would think that the doctor, if they didn't have to pay for that substance by producing it themselves, they are saving money, right? Is that fair?
Fair.
Right. So you mentioned the lab tech switching out. Why? What incentive would a lab tech have for doing that?
I don't know that there's much incentive other than with the evidence we do have or that we've heard. He very much just said he switched it out because the woman that came into the clinic was hot, to be quite honest.
So, I mean,
I can't speak for what
the mental
incentive
health
was.
issues aside of doing that, it's your understanding that he wanted to be a part of that woman's biology. Is that fair?
I mean, that's what I'm assuming. And the only consequence he got was that he was fired.
Yeah, understood. I mean, I think it's a different situation perhaps than what we're dealing with in the legislation before us. And I'm just trying to, wrap my arms around the whole situation. So
I just use it as an example as why we wouldn't want to just say physician, because I think that down the line, there's going to be so much, unfortunately, the last woman who spoke said that this is of the past. This is still happening. And we are only now just finding out about all the disgusting ways that we can complicate this really amazing process, which is, as a woman, you're in this trusting and vulnerable state going through fertility treatment. You just want to trust the process and the doctors and everyone that's involved. And the fact that anybody that has any kind of access to gametes or this process can ultimately knowingly and intentionally choose to do something deceitful, I think there just should be a law for that.
Yeah, understood. As I did bring up the physician thing at the very, very beginning. I'm just trying to, you know, I guess I got to separate the mental health aspect from that act. But I thank you. Thank you for coming here today.
Thank you.
Further questions or comments from the committee? Further questions or comments? Representative Porter.
Thank you, Mr. Chair. And I just wanted to align my comments with what's already been said and just to commend you on your testimony today. Absolutely sorry about what you all are going through. But great job. You did a great job today, and I just wanted to let you know. Outstanding. Thank you for your intestinal fortitude and the courage it took for you to come here and sit before us and share this today. Yes, God bless. Thank you, Mr. Chair.
Thank you. Thanks for being with us. Olivia Wasserman.
We have 3 generations of which this affects.
Wow.
My name is Olivia Rose Wasserman. Hi, my name is Olivia Rose Wasserman. I am 7 years old and I live in Wethersfield, Connecticut. I support Bill 5423 because it will protect families in a way that was mine is not. I think my mom is a minion because a doctor made a bad choice and harmed my family. I don't know all my health history. I don't want to marry a cousin. There are a lot of us. I don't think that this kind of thing should be allowed to happen. Thank you.
How old are you?
7.
Oh my gosh, 7. All right. Well, you might have a future up here on this side someday with the route you're going. So I'll be on the lookout. I'm hoping you don't. Whose district you live in? Senator Lester's. Senator, be careful. All right. But great job. Thanks for being with us this morning. Seeing no other questions or comments, that brings us to the end of our public hearing. I will declare this public hearing closed, and we will see everyone on Wednesday.
That would be me. It's today's state of Connecticut flag, which I think you should have. You want to show all your friends? You're part of your government flag. You can come here and steal whatever you want. All of us will make up the statements. And you can wear that to let them know that you can participate in your governmental process, okay? So good job. You did an excellent job, all right? Nice to meet you. Thanks so much. We're sorry about that.